Dear students, I have come with a new module, express and implied conditions. Now you know what you mean by condition. So that is a statement which is made by the seller and that will form the root cause of the contract. So there are certain express conditions and implied conditions. Express condition meaning the seller is saying, make it very relevant that this is applicable in the sale of contract or that is present. Whereas implied meaning it's understood. So in this module, we are going to check what are the express and implied conditions. Now, condition needs to be satisfied by the seller. So that is very important. If the condition is not satisfied, the buyer can take action. That is for legal remedy. So that because the condition is the main thing we are entering into a contract. See, for example, if I am buying a hot water bottle, I will tell the chemist that I want a hot water bottle. That meaning that whatever I'll get, he will give me, that should be possible to use as a hot water bottle. That is a condition. Buyer has the right to know the conditions beforehand. If there is any specific thing related to that hot water bottle, you cannot add boiling water or anything like that. He has to mention clearly. So buyer has to know the conditions beforehand. That's the seller's responsibility and duty to tell that. Now, what are express conditions? Express conditions are mentioned in the contract of sale. So by word spoken or written, it's mentioned. And it's mutually agreed by buyer and seller. That meaning both the parties. So, and this you have to remember, express conditions are assumed to be present in a contract of sale. Now, you have to remember it's understood that it's present in a contract of sale. See, for example, if you're buying a feeding bottle, you don't have to mention that what is the use. If you're buying a wheelchair, if you're buying a trolley, if you're buying a ladder, it's assumed to be present in the contract of sale. The use, we don't have to go and tell that. It's express. Now, what are the implied conditions? An implied condition is neither written nor implied by any party. It is automatically implied by law and it's assumed to be present in a contract of sale. Now, section 14 to 17 of the Sale of Goods Act 1930 explains the implied conditions. So there is a lot of difference between express conditions and implied conditions. Implied conditions, you can take it for granted because that will be already there. Whereas express condition, the seller will be telling specifically. See, when you're buying a water purifier, they will be specifying certain features about that product because different products are there in the market. They will specify. Reverse water purification is there, RO water, all this, certain specifications. These are the conditions. Now, what are the implied conditions? There are 7 points. First, I'll list that, then I'll explain one by one. One is condition as to title. Second, condition as to sale by description. Third, condition as to quality or fitness. Fourth, condition as to mercantability. Fifth, condition implied by custom. Sixth, sale by sample. And seventh, condition as to wholesomeness. So, let us explain one by one. First is condition as to title. So this clause is as per section 14 of the Sale of Goods Act 1930. That means implied conditions are explained from starting from section 14, it's ending with section 17 of the Sale of Goods Act. Now what is condition as to title? When a seller is selling something, offering something for sale, we have to remember that the seller has the right to sell the goods. I assume that seller has the right to sell the goods. For agreement to sell, if it's an agreement to sell, seller has the right to sell when the property has to transfer to the buyer. We know that in agreement to sell, the ownership will transfer on a later date. If the seller is not the owner, buyer can reject the goods. Any chance, if they'll come to know that, if the buyer will come to know that, even after purchase, if he'll come to know that seller was not the owner, buyer has got every right to reject the contract. So this case is Roland versus Diwali. So that means Roland bought a car from Diwali and Diwali has sold the stolen car. That meaning he is not the actual owner. So Roland has got every right to collect the refund and return the car to Diwali. So this is an important thing. Seller has the right to sell the item. Second is condition in sale by description. As per section 15 of the Sale of Goods Act, condition with regard to sale by description is explained. So goods shall correspond with the description of goods. How we buy certain things, especially when we buy provisions and all. We have to remember, if sugar, from the bulk we will check. So if it's according to our satisfaction, we will purchase. Rice, paddy, everything. So buyer has not seen the goods and relies on the description by the seller. So sometimes when we are buying online, the online merchant, they will be giving the photo, they will be explanation they will be giving. So we are not getting a chance to physically inspect the item. So the description, whatever they are giving in their website or their purchase site, wherever they are giving that information, whether it's an advertisement, that we are taking it for granted, that we are taking it as correct statements. So on that basis, we are buying the sale, or we are making the sale. So the second point you have to remember, buyer relied on the description of goods. It can be an advertisement, it can be an information in the website, or it can be there over the phone, they are giving that information. So packing of goods also is part of description. Sometimes the green sign will be there. That means whatever the contents, it's vegetarian. So that is condition in sale by description. We have got every right to rely on the description given by the seller. Now third, condition as to quality or fitness. As per section 16 of the Sale of Goods Act 1930, condition as to quality or fitness is explained. So buyer has to check whether the article is suitable or not. Buyer has to check. That meaning it is the duty of the buyer. So the usual principle in sale of goods is caveat emptor. We have to take certain precaution as a buyer. When you want to invest something, when you want to buy something, you have to do some research and you have to find about that quality, quantity, everything, from the reputation, whether there any service guarantee, everything, from relatives, friends, wherever you can collect information. It's the buyer's duty. So when the buyer makes it known to the seller his requirement, the condition will change. That meaning, buyer is going to the seller and telling that this is the purpose I am buying. So in the case Priest versus Last, this case happened in 1903. Priest is a textile merchant. He went to the Mr. Last, that is a pharmacist. He went and told that I want a hot water bottle. That Last gave the bottle saying that it's suitable for hot water. It's not suitable for boiling water. But Priest used that bottle for boiling water because he mentioned that he's a textile merchant. He doesn't know anything about that. So he gave that bottle, Mr. Last gave that hot water bottle, which is, we can use only hot water, not the boiling water. So here, when Priest used that hot water boil bursted and he was damp, he got affected. He got burns. So then on that basis, Last was asked to pay the compensation. So this is the case, because here in this case, we have to remember, Mr. Priest has mentioned the requirement, why he is buying that. I want a hot water bottle which can use boiling water. And Mr. Last, as a pharmacist, he should have listened to that and gave the product appropriately. Or the proper product, he should have given it to Mr. Priest. So in this case, Mr. Last lost the case and Mr. Priest won the case with the compensation. Similarly, in the case Baldry versus Marshall. So this case already I have explained. Baldry went to the Mr. Marshall, a car dealer, and told that I want a car for touring purpose. He gave that car, Bugatti car, saying that this is good for touring purpose, but it was actually not. So in this case also, Mr. Baldry won the case and Baldry returned the car to Mr. Marshall and got the compensation also. Now, implied condition as to fitness will be applicable for sale to a normal buyer. Imagine if it's a person totally different. So if the buyer bought an item under the patent name, there is no implied condition as to its fitness. So before that, I want to tell you one thing. Normal buyer. Sometimes when you're buying a medicine, if you're allergic to skin disease or something or anything, if you're allergic, especially when you're buying medicine, you have to tell that. Or when you're going to a doctor, you have to tell that clearly you are allergic to certain medicine, or you have some health disease and all. Because otherwise, if you are not mentioning that, the doctor or the pharmacist will give you the medicine to a normal person. They will believe that you are a normal person. So that is the thing. If any special case is there, you have to mention that to the seller. Second is, if the buyer bought the item under patent name. When you are going for certain company names or any Tata company, Reliance or any product, then that meaning you are asking for that particular product. So that you are responsible. The buyer is responsible. Next is, if the item can be used for a number of purposes, buyer must specify the purpose. If you're buying a product, skin lotion, it can be used for any other product, a whitener or face whitener or anything like that, many products. Then you have to specify the purpose. This is the purpose I am buying this product. Next is a person buying paper. Another example is a person buying paper from a wholesale paper dealer. He has to mention that whether he's going to use for writing purpose, whether he's going to use for printing purpose. So it's very important. Fourth point is condition as to merchantability. The term merchantability implies two things. One is, if goods are purchased for resale, it is capable of selling again. Some people, that wholesale dealers, manufacturers, they may buy something which they want to sell it again. So the person who's buying an item for resale, he's getting the right to sell that item again. He's getting that ownership. There is nothing preventing him from selling that item again. Second is, if goods are purchased for self-use, it is fit for the purpose for which it is generally used. See, for example, if a person can buy car under two situations. One is for own use. Second is a second-hand car dealer. He will be buying that car for the purpose of selling it again. So these are the examples in this case. Now, three conditions have to be satisfied for these conditions to apply. One is, goods are bought by description, by explaining. Second is, seller is a dealer in that goods. Seller is a dealer in second-hand goods. Third, buyer has got no opportunity to examine the item. If buyer is not examining the item, condition as to merchantability will apply. Fifth is condition implied by custom. Buyer need not specify the purpose of purchase in some cases. Example, wheelchair, feeding bottle, trolley, ladder, etc. When we buy that item, both of us, the seller and the buyer, is aware that why they are buying that item. That usage of that item is understood. Now, sixth is sale by sample. As per Section 17 of the Sale of Goods Act 1930, the bulk of goods purchased must correspond with the sample. See, wholesale dealers or merchants, they see the raw material, they check the sample and they will do that. They will buy that. Similarly, if it's a manufacturing company, they will, all the items they may not be checking. Sometimes they will take a sample and they will, if it's found to be correct, they will assume that the entire product or the entire lot is without damage or the fit for sale. So buyer got reasonable opportunity to compare the bulk with the sample. Buyer should get when we go to a supermarket, that is what we will do. When we buy the daily provision or monthly provision, we get an opportunity to check that item. So defects in goods are not apparent on reasonable examination. See, if I'm buying atta, it's packed. So I'm not able to see that if worms are there inside. When I go home, I have to open and see that where worms are inside. Then only in the shop, I'm not getting an opportunity to open and see that. Now, last point is condition as to wholesomeness. This condition is applicable for eatables and provisions. What we buy, the items what we buy to consume, because it should be healthy. So this condition is that goods are fit for human consumption. So in this case, Chaprenier versus Manson, that case is there. Mr. Chaprenier purchased a bun from a confectioner's shop. Mr. Manson is a confectioner, bakery. So here what happened, in that bun, one stone was there and Mr. Chaprenier was eating that bun and he broke that. His teeth he broke. So he filed a case for that and he got every right to, he got the compensation for that. Because when you buy a bun, we never expect that one stone is there inside or one dead cockroach is there inside or some ants are there inside. When we buy an item, we expect certain quality. So that is the confectioner's duty to keep that item. So in this case, the case was in favor of the person who bought that bun from the confectioner's shop. This is what I wanted to explain. Happy learning. Thank you.